welcome to the Steve Fox Show, where it's you and the law, where you have an opportunity to call in and ask two attorneys and get some free quasi-legal advice, no consultation fee. But before we go on to that, at popular request, it's time for another happy attorney story. At the request of Fred Harkins, one of our local chiropractors, we're giving another one of these stories. In one of my cases, we have this girl sitting behind a bush right near a school, waiting to lunge out on my client's child. She lunges out, hits my client's child. Of course, the child falls, hurts her neck and back, which is typical in this type of situation, very legitimate. Now, who do you sue? Well, the parent is legally liable for the torts and actions of the child. So we went after the parents of the girl who lunged. Who do you sue? The homeowner's policy. They average to at least have $100,000 in coverage, but they only cover negligence, not intentional acts. So was this lunging intentional? Or perhaps, as my argument would have it, she negligently jumped up as much as she did. Of course, we settled for $9,000, and of course the client got their share, the chiropractor got paid, and yes, the attorney lived happily ever after. With that, I am now going to introduce one of our family law specialists, Wild Bill Koch, who's one of the excellent attorneys in Lancaster. Bill, welcome aboard.
Well, thanks, Steve.
I want to let you know that I appreciate you coming on the show. I have a few questions I've been meaning to ask you to start out on some hypothetical cases. The first one, of course, is, in fact, why don't we talk about your practice on getting divorced or going broke? Tell us a little bit about that.
Well, I think it's a main consideration for people. I think when people embark upon a dissolution process, they know it's going to be really expensive, and I think they don't realize how much control they actually have over this, and whether it's going to cost them a lot of money or whether it's going to be a reasonable resolution to the problems that they have.
I've seen, my case is, 2,000 up. I've seen 40,000 attorney fees. I've seen things go on for years. How does someone control this, or what do they do?
Well, I think everybody's got to have a perspective of what they're doing. I mean, family law in its own way can be crazy. I mean, you've been there. I mean, we've seen one another in court, and every case imaginable has come before the judge over the years that we've watched. But I think what happens is that people get involved, and a lot of times I think attorneys take the cases away from their own clients, and I think that's the unfortunate aspect. I think if you watch, if you look at a case and if you analyze it correctly and if you talk to the clients and if the clients know what's going on, I think that you can probably resolve it a little bit quicker. Let me give you an example. I mean, I think if you're looking at somebody that two working parents, they have a household income of like $60,000 to $70,000 or less. They have a couple children. They don't have any retirements involved. They have a house. They can make a choice. They can either sit and be involved in litigation for 2.5 years and spend thousands of dollars on both their attorney's fees, or they can sit down and do some soul searching and say, hey, what do we got to divide here? What's the issues? And try to sit down and really do it right.
And I'd agree with that. I tell my clients, do you want to give the money to the attorneys, which I don't mind, or do you want to save the money for the kids' college?
Right.
And if they're logical, they sit down, they figure out where the differences are, where the disputes, and they resolve those specific ones. Because if they just want to fight, the only ones they're helping, unfortunately, is you and I. Well, I tell them that.
Yeah, and I think that's right. And I think you see a lot of people come into an attorney's office and say, they're hurt, they got a lot of pain, they're angry, they want revenge, they want to be somehow righted from all the wrongs that have taken place. And so I think they come in and they hire an attorney and they say, you are my knight in shining armor, go out and do the big battle. And I think an attorney's role is to really bring them back to the center and say, that's not really what you want to do. What you want to do is take a look at it, realize that your marriage isn't going to work, and try to figure out a way how you're going to divide what you have and get on with your life.
And I would agree to some extent the divorce has become a division of assets. It's a no-fault divorce, although I'm thinking they're slightly putting fault back in as far as how you handle yourself in the discovery process. If you lie, then you can get punished. But basically, it's a no-fault divorce. We don't have to relive the marriage. We don't have to look at every wrong. We're not looking to show if one party cheated on the other. We want to divide the assets as equitably as possible, and at the same time, create some kind of protection for the child.
Well, I think that's true, but I think even more important than that, I think it's incumbent upon the client or the prospective client to come in and say, I want you to do this. Sometimes clients will come in and then say, I don't care what it takes. I want you to hurt this person, and you have to tell them, that's probably not necessarily in your best interest to do that. We need to look at some other avenues and deal with it. But a lot of times they can't get over that, and I always tell almost everybody that comes into my office that in every case it's there's this bell curve. People come in, they're hurt, they're angry, they want to inflict their wounds on the other party. They want to do all this, but after a period of time, whether it's a month or 3 months or 4 months down the road, I think everybody realizes that the only people that are making money here are possibly the attorneys, or all the assets are being soaked up by the process. So then they finally realize, okay, well, I think it's time to probably settle this case. Our job, our role, I think, is to basically try to fast forward the process to get them to that stage quickly as possible before they utilize or use up a lot of the resources they have available to them.
What I find a lot of times is when one party runs out of money, then they want to settle. And what happens is when the party runs out of money and the other attorney drops them, then I sit both parties down, and though I represent my client and that's my job, I say, look, again, you guys are at the point of you spent quite a bit of assets. Let's sit down and work it out. And ironically, a good percentage of my cases are when there's the other attorney is left. And when you have two attorneys, we can generate, and not intentionally, but while we're doing our job, a lot of paperwork. And a lot of times we're just doing what we're told by the client. But like you said, we both of us, you and I, try to bring the clients. We have to do what they say, but we have a duty to tell them, hey, you're wasting assets. You're not really hurting the other side. If you are, you're hurting yourself too.
Well, I think people think in a lot of ways, if you come out of the chute in a really angry and aggressive manner, that the end result will be a lot more favorable to yourself, and I don't agree with that. I think lawyers. I think it's their responsibility to take advantage of the opportunities as they present themselves in the beginning. In the beginning, you have two people that have decided to part ways, and I think at that point in time, there's a way to try to explore reasonable alternatives to try to settle the case. If you miss that opportunity, if you blow it, then you set up yourself for a much more vigorous battle, much more costly battle, and you're back to that bell curve where you're projecting yourself to any possibility of settlement for months and possibly a year or so down the road.
What are some of those options that they can take which will end up costing them less money? What are some of the ways to do things?
Well, I think a lot of the ways, I think the most thing is to have a good support group. I mean, to have somebody talk some sense into yourself. Get together with people that are supportive of the situation that you're in. And then the next thing is to take inventory of what you got. I mean, a lot of people don't even take that step, and a lot of lawyers aren't as astute in trying to define what they do have. And once you can sit down and you can evaluate the property, the debts, what you want to do with your children, find out what all the issues are, then you can be a little bit more businesslike about it. You can sit down and analyze what's going on. You've already decided to get a divorce. Now is not the time to in your own mind, for the client, to relitigate all their failures and what's happened in their life. Now's the time to try to save some of the assets that they currently have and take a look at it. It's kind of like a one-shot deal in the beginning. I mean, if they really took a look at that and really decided what the scenarios are, then it becomes much more limited, much simpler for even a judicial officer if you should ever have to go that far. And that's the other key, is to try to keep it out of that court system.
The richest clients I had, we never went to court. They sat down. I represented, without mentioning names, where I ended up getting my client $12,000 a month and quarterly payments of $25,000, and I stuck in the section that even if you get remarried, and this isn't normal, you can still collect your spousal support, and there's a case on that. But they were smart enough to realize that if they went to court with the assets they had, a lot would be spent with attorneys. So the richest clients I had sat down, determined what the issues were, divided the pensions, how much the child support was going, how much the spousal support, who got what property and for how long, and actually was for a specified period of time, unmodifiable spousal support, which again is rare and is limited in many cases. But they determined the issues, and they saved in attorney fees. And I have to agree with you, but most of our cases aren't like that, Bill.
Well, I think that's true, but I think we have a procedure now, and it's been around for a while, obviously. But the preliminary declaration disclosure is one of the very first projects that I think every client
Why
that
don't you
comes
tell
into
our
court does
client
that.
what the preliminary declaration of disclosure is, so they know what we're.
Well, a preliminary declaration disclosure is a document that's filled out by and filed and served on the other side by the party that basically lists all the assets and debts of the relationship. And I think it's a lot of attorneys on behalf of their clients don't do a really good job at that. If it was done really well, then everybody that would receive that document would actually know exactly what needs to be divided. I mean, the main sting of the story or the whole process would be over. It wouldn't have the effect that it does later on when people don't know what's going on. A lot of people argue about things and go to court about things that don't even exist, and that's what just really amazes me. I mean, people will argue for years about the value of a business or the value of a pension plan or a 401k and never ever know what that value is and until the very end. And if they would have known that up front, it would have been so easily divided and the parties could have gone.
So you think some attorneys are not servicing their clients perhaps as well as they can by not trying to solidify what the value of the different items are so that we can move forward dividing them?
Well, there's different types of discovery, as we both know. There's the informal discovery, and then there's the formal discovery. I mean, on the basis of for filing the declaration disclosure, it can be all encompassing. Then there's formal discovery. It can be depositions. They can be special interrogs. They can be all these other ways that we can go, but they're costly. They're costly for the client. They're time consuming for the lawyer. And in cases where there aren't a lot of assets, they are a waste of time.
I
It could have
agree.
been done. And I think if people get together and require that the declaration disclosure be accurate, then they can save themselves thousands of dollars on the other end. And I think that's important.
Now, let's talk about basically how the law is changing on a lot
Is
of
it changing?
things. Well, it depends on who you talk to.
Is it written down here? Let me see.
No,
Oh, okay.
one of my hypothetical cases.
Oh, okay.
Funny you should mention that. So now, if there's a difference between a short-term marriage and a long-term marriage regarding support, the way it used to be, and there's about 10 years, that if someone's married under 10 years, they usually get spousal support for, say, half the term of marriage. If it was 10 years or more, they could possibly get it forever. Now, I've noticed that forever is changing. I had one case where one of the commissioners in one of the courts, even though it was a long-term marriage, only gave my client a year of support and then terminated it based on need or what the party could do in the future. How exactly is that changing? In a long-term marriage, if someone comes to you, what do you tell them? And I know every fact is different. How long can they expect to be paying the other spouse or receiving from the other spouse?
Well, there's the legislative intent is that everybody becomes self-supporting within a reasonable amount of time. I mean, that's the standard that we all utilize, and so everybody wants somebody to take up the task of supporting themselves if they have the ability, the age, and their health is okay, and all the other factors of 4320 in the family code. But I think really the issue as it's gone through the legislature, although they wanted to have a halfway point to cut off in support and say enough is enough, they also realized that it worked very well. And for one instance, I mean, if you're 18 and you're married 10 years, and now you're 28, is the other party going to be required to pay support until this person is
You have all
80
those
years
years
old?
still to be able to get a new
Sure,
job and
exactly.
generate.
Yeah, and go to college, become a brain surgeon, whatever they want to do. But on the other side, what happens if you get married when you're 50 and now you're 60 and you retire? Well, you probably won't be able to do that. You won't have those same opportunities. So every case truly has its own flavor or set of facts, and I think every judge, because spousal support is what it is, has the discretion to make those determinations of whether somebody is truly making that effort to be self-supporting, and if they are, there is a time when the payor, the party paying the money, should be able to be relieved of that obligation.
So it's based on ability to generate, it's based on need, are those the main factors that the judge is going to look for?
Well, the factors are all laid out in the family code, but I mean, it's the age of the parties, it's whether they've been a homemaker their entire career, it's whether they've had any education, what their skills are, it's what the job market is based upon what their skills are, it's based upon their efforts in the community, it's based upon whether they stayed at home and put the other party through school so they could have a career. There's all those factors involved, and I think that's what makes it difficult for a judicer, and it's difficult for us to argue. But that's what it
you
is.
beat me on one case where, and I was only in for a short time, probably because you beat me.
Really?
Whereby the parties were married for approximately a month, and this is a hypothetical, of course, and the other spouse became disabled. So instead of half the month as far as the length of time to get spousal support, you were getting it forever. So what is the tendency, do you think, in the law that if the other spouse becomes disabled, how long should support continue? And should the supporting spouse also have to pay, let's say, health insurance forever?
Well, that's an interesting one. I really don't know the answer. I mean, and I don't think anybody could tell you. I mean, the Woods case is the most important case in that area, where I think she was a barmaid. She had a brain tumor, and she was paying support. The payer was paying support for a long time, and the court finally said, enough. Now it's time to shift the burden over to society. But I think when I talk to judicial officers that are making those kind of determinations, they like to phrase it like the pathetic factor. I mean, if somebody comes into court and they are so pathetic, and I mean they're so pathetic from the standpoint that they'll never be able to work. They have a terminal illness. They can barely get up in the morning. The others the person, the payor, has a great job. They'll always be able to work. The other person never will be able to work. Well, I think there's a tendency to allow and to continue some kind of support for a wild fourth person.
Now, looking at the health insurance question, I have clients that says, well, will my health insurance continue because I'm getting it from my husband or my other spouse? And I tell them, COBRA, which is what you convert health insurance to, usually lasts for just 18 months. What happens is at the end of the divorce, it normally shuts off. What if the other spouse becomes disabled? Is that other spouse responsible to now pay past COBRA and keep paying that health insurance?
Well, I think the concept is that spousal support and all the benefits associated with it are forever modifiable. They're always modifiable depending on what the conditions are. If you have
support, or does that include the medical health insurance also?
Well, if you have medical health insurance and the court hasn't made any other order, made it inclusive of spousal support, it terminates. There is no obligation for medical insurance beyond that. I mean, your only obligation is to not terminate it, to not create a situation that harms that party. But there isn't a built-in obligation to maintain support plus spousal support and all the other support issues.
So health insurance. But could the court order that? And I'm just curious, or would it say spousal support is going to continue longer, and that injured spouse can now, or damaged spouse can now use that new support to purchase their own health insurance?
Well, I think the court can always make that determination. Absolutely. I don't see that as a problem. I think the issue is that can the court, if the court orders COBRA and for somebody to pay COBRA, and if the terms of it are to maintain it for a period of years, then they have to maintain that.
Because health insurance connotates life, and a lot of times only one spouse has the benefits in their job. And the jobs will terminate that support when you're no longer married to that other spouse.
Then it's done. We don't have involuntary servitude.
And with that, we'll take a break in a minute, but I remind the audience that you can call at 726-0382. Call in 726-0382, and you'll be able to ask Wild Bill Koch here, who's one of our family law specialists out here, a question, or myself. Thank you very much. Welcome back to the Steve Fox Show, where it's you and the law, where you have an opportunity to phone call in and get advice from two attorneys, quasi-advice. You may want additional advice at our offices, but call in at 726-0382. And tonight we are privileged indeed to have Wild Bill Koch, one of our family law specialists here, who is going to talk about how to save your money. Bill, how do you save the poor client?
Well, I think, one of the things I think everybody has to be cognizant of is that when you're dealing with the lawyers, you're spending a lot of money. Whatever the hourly rate is, it's costing you a lot of money. The things that you can do to save money are to try to investigate if there's any areas that you can settle with your other spouse, or are there issues that you think are ripe for trying to open up some kind of negotiations to settle. you really have to figure out in your own mind, what are the issues you really want to fight for? I mean, what are the issues that have to be taken to a judge to make the determination? And what issues can you sit down and try to manipulate or give a proposal to the other side?
I think what Bill's trying to say is we're only as good as the ammunition you give us. If you've worked out something, it's one less issue we end up charging you for. You settle the whole thing, we drop what's called either a marriage settlement agreement or a stipulated judgment or some agreement where it irons out the issue, or just a stipulation of one specific issue, but it's one less thing you're going to have to pay us to work out. So what Bill's suggesting is hopefully putting us out of business where people learn to work it out and get along. In fact, we're not necessarily for divorce. I've had clients who say, I don't really want the divorce. And I've suggested, fine, go to counseling, stay married. I think it's a great institution. But in the event that you're not, I'm here to help you through it. And the more issues you can work out with your soon-to-be ex-spouse, the less it's going to cost you.
Well, I think that's true, but I think more important, they wouldn't come to you unless there was a conflict and they couldn't work it out. I mean, we all understand that why they're in the office, why they hire an attorney, but what I'm trying to get at is that during the process, there are windows of opportunity where certain issues can be resolved, and you should make every effort to do that, because if you don't do that, somebody else is going to have to resolve those issues for you, and it's going to cost more money. So it's a process. It doesn't happen. You're not going to sit down with your spouse or whatever and resolve all the issues involved in your dissolution, but you can get rid of some of the issues, whether it's dividing up the pots and pans or the family pictures or the automobiles or the timeshare with your children or whatever it is. You can eliminate some of those issues and leave the few that have to be decided by either a judge or to be arbitrated later on to somebody else, but you should make every effort to try to resolve those. It'll save you a lot of money.
So instead of letting the judge decide, we have a thing called a four-way conference where the two parties and the two attorneys get together in one of our offices and see if we can work out some or all of the issues. And what I tend to do is when I do that, I've got my secretary standing by, ready to type whatever we've agreed to. Notice is when they leave the four-way, a number of times they have what's called buyer's remorse. They change their mind, they really want to fight. If I've got it right there and they've agreed to it, a lot of times they'll sign it. And the next morning I file it with the court, and it's one more issue that doesn't have to be litigated because the courts are pretty tied up and it may take forever even to get to that point. It's one more issue you really don't have to pay to send the attorney to court.
And I think that's important. I think if you can resolve those as much as you can, then you're way ahead of the game. There's a saying amongst judicial officers, and the saying is that if they decide a decision in a divorce case and both the parties walk away unhappy, then they know they've done a good job. If one party is happy and the other party is unhappy, then they know they've failed their role. So,
what if both parties walk away unhappy?
Or both parties walk away happy? I don't know. I think if they both walk away unhappy, and that would be what I think the judges, he would be happy at that. But I think that the issue is really if you want to have control over your situation and have a resolve that is more satisfactory to you, then you want to take some kind of responsibility for being able to do it. I brought along here these, I thought was pretty good. I hand out to all my clients the complete dissolution threat list. And I think the threats that we get involved with when we go to get involved in a divorce are what fuel the fires. And some of the classic top list of threats are, I will tell them X being whatever it could be, to discredit you or whatever, therefore you will never get the children. I mean, all these things that people say to one another, the most cutting, ridiculous, accusatory statements that are made from one party to the other, are just the things that drive people on to further cost, more lengthy litigation, and also to embarrassing moves that people make in retaliation for comments made by
Bill,
another
I don't
party.
like this one here. It says your attorney is a dud. Is that supposed to...
Or out to get your money, or why don't we use one attorney and save money,
Well,
or
now
your
that
attorney
makes
is really
sense.
partial to me. Yeah. Well, I mean, those are all the things that I think people say. It's almost like, I mean, a long time ago I was told by another attorney, a friend of mine, that the difference between criminals and people that are involved in the family law process is that criminals are bad people. They've done something bad, but you can bet that they're on their best behavior when they go to court. I mean, they know they're facing jail time. They're going to do everything they can to please the judge, or whatever they can do to get a good sentence or whatever, get a good result. But in family law, you've got really pretty much good people that probably very rarely been in front of the criminal system,
Oh.
done things, but they're on their worst behavior. They'll do things that you could never even believe.
Well, you know, I've kind of mixed the two. I had one case where I walked in representing the lady. This is downtown LA. The husband had the kid. The lady comes over to me and whispers, I think there's a bench warrant out for my husband. I go over to the bailiff. I said, would you run a quick check? Sure enough, there's a bench warrant. So all of a sudden they arrest the other side. They arrest the other side. So I go, Your Honor, now that the other side's arrested, he can't take care of the kid. We like custody of the kid. They gave it to my client. Then I said, now that we have had custody, we'd like support. They gave me support. So my client walks out with a big smile, with the child, and with support order, and the other party, unfortunately, walks away in chains. So you don't always get the cream of the crop necessarily, although I know in our family law court, they don't usually check for warrants, but I have run checks and do bring that to the attention of the court. But you're right, even in family law court, people can show their worst sides.
I don't know, doesn't that fall under the saying that even a blind squirrel stumbles across a acorn once in a while?
Thank you very much. My acorn, I really appreciate that.
Sure, that's okay. No, but you know, I mean, I think that in a lot of ways clients don't think that they have, or they feel so powerless when they get involved in the system, and they really actually have a proactive stance that they can make, and I would like to see them doing it more and more.
So you're looking almost a self-help to work with the attorney?
Well, not self-help. I think that there should be more interaction. I think, truly speaking, I think a lot of clients believe they hire an attorney, they give it to the lawyer takes this case, and they don't understand anything at all until 2.5 years later they end up in court and they're thinking, you know, it's taken 2.5 years. I want my day in court. At least I want it over with. They don't realize that through that whole process, there were things that they could do. They could call the staff. They could say, you know what? I think we've settled this one issue. Why don't we do this four-way? Try to settle this case. I'm tired of fighting. Let's get it over with. Let's keep it out of the court. Let's hire a private arbitrator. I mean, there's so many ways to diffuse this whole process instead of going through this thing where you get a court date 6 months down the road and throughout that entire time you lose all the initiative
What
to try
I
to
think,
settle.
Bill, what you're saying is that we wait for a judge and the courts unfortunately are backed up. There's other alternatives. We do four ways. We do mutual agreements. We stipulate to an arbitrator, an impartial person that can act as a judge. We can do a binding arbitration. So there's a myriad of agreements as long as the parties are willing to agree.
Now there are times, and I think they're probably somewhere between 5 and 10% of the times, where you can't do anything. You need to go in, you need to put it on, you need to have a trial, you really need
Cries
that.
out for the trial and for justice.
Well, it cries out for resolution, and nobody can settle it amongst themselves. And I think in those particular times, fine, let's do it. That's when we take on our adversarial role, and that's when we really do what we do. But there's also the negotiation side, and I think there's a lot of lawyers that aren't good negotiators, don't want to do the negotiation side for whatever reason, and I think that's costly to the client.
Since I do family law and PI, I've had a family law attorney say, this isn't a PI case, we're not going to negotiate. I mean, I've had some, hard-nosed individuals, but I agree with you. Sometimes you have to look, if it's possible, for a win-win, where nobody gets everything they want, but nobody gets totally hurt either, because the realization, especially when there's kids involved, is you had kids together, you took the time to do that, you're going to have interaction till that child or children turn 18 years old, or till they graduate high school up to 19 as the code implies. So you're going to have an interaction. So if you hurt the other party too much, if one side's a winner and one side's a loser, you're both really the loser.
Well, yeah, but what I'm really trying to say is that I think clients have more power than they think. They hire the lawyer. We are the people that they have hired, and they've hired us. They can fire us. They have the power to basically define our role. And I think the most important thing we do when we're in a consultation or when we're dealing with clients is to try to find out what is it that they want. I mean, what is the role that they want us to do? It wouldn't be right for a lawyer to say, every case that I do, this is how I do it. I'm a good litigator. We'll wait till we go to trial, and by golly, you're going to see how I really am. I mean, that's ludicrous. I mean, what you want is a client to tell you, Mr. Fox, I'd like you to see if you can't negotiate these things. I really don't want to go to trial. I want to see what kind of efforts you can do in this area, and that's what we're hired to do.
Well, sometimes I find that people hire attorneys that are very similar to themselves. If the parties didn't get along, then the next question is, how do attorneys that are similar to those two people get along? But I've noticed on a number of occasions that happens. I've also noticed that about 90% of my clients that hire me, I have the wife in the divorces. I'm not quite sure why, but that's what I seem to end up with, that at least when I sit down in a consultation, that's what ends up hiring me.
I've kind of noticed that about why people buy certain kind of dogs. They buy dogs that kind of either kind of look like them or kind of act like
Well,
them.
I don't think that is fitting in this case.
Oh, I'm
but,
sorry, okay.
But you're close with your humor.
Oh, I'm sorry.
And I must commend you on some of the extremely good tactics that you've used on me on a number of occasions and beat me. We had one where my client was avoiding service because there was an interstate problem, and you called a depot, and we showed up, and sure enough, we got served at the depot. So
I did that?
Oh, but you were extremely efficient and extremely intelligent in your tactical maneuvering. So I want to commend you on that as well. I've learned quite a bit from you.
Well, thanks.
But going on, and I have to agree with you, clients should be empowered. I always tell my clients, and I probably have the least client control of anybody, is because I tell them, you're the boss. I do what you want. All my job is to give you options. I give you which option I think is the best, where we're going to go. But again, I don't want to lose the client either. I want to help them as much as I can. And that's kind of the direction I take.
Well, I think it's important to understand that people, when they go through a divorce, it's one of the worst things that they can ever be faced with. It's stressful. It's devastating economically. It's divisive to the children that are involved in the home.
Without question.
I mean, it's incredibly difficult, and I think it's I think an attorney's role, I mean, we're not to be counselors. I mean, we can't really fill that role, and people should clearly get counseling or support from whatever their family units or supporting groups are. But we need to understand what they're going through and try to guide them, and not let them go into the fallacies of what a lot of people think divorce is, which is just rape and pillage and do. Yeah.
Almost like a war.
Yeah.
I want to give out the number here again. If you've got a question, you're out there. It's 726-0382. But in addition, if you want to talk to Attorney Bill Koch in his office, and again, he's an excellent attorney, and I've got to give him that. Bill, what's your number at your office?
My number is 949-6727.
And you can give him a call at any time, and you make an appointment for a consultation, whatever the typical consultation fee is. But tonight you get a free one on Bill. If you call in on the phone, it's 726-0382, and you'll get a chance to ask Attorney Bill Koch a question. How many years have you been practicing now?
Well, I was admitted to the bar in 1978.
So you 22, 23 years, something like that.
I don't like to count anymore, but that's okay.
Does that indicate your age? Or? But speaking on some other things that I've been asked, just to switch gears for a second, some people come to me and say, I have never seen the child, now I'm being hit for support. Do you think it's appropriate if someone's never seen a child in an establishment of parental rights or something, didn't even know the child existed, and now they're being hit with arrearages or support? What are the rules? Tell our audience on that.
Well, it's unfortunate. I think the legislature has placed the burden on biological parents to support their children no matter what. And I think there isn't a justification. I think if you are the parent of a child and you haven't seen the child, there are things that you can do to try to find the child, to see the child, to develop a relationship. And if you haven't done that, you're going to pay.
So let's say someone hasn't seen the child, didn't know the child existed. 3 years later, they get hit with an establishment of parental rights or a DA case. Should they have to pay the arrearages for 3 years, or what? What do you? Or if they've, and you know something, the DA won't give out the address, so you can be hit with the arrearages and still not get the visitation.
Well, I think that's true. I mean, you are a co-creator of this child, and you are responsible for its financial support.
What about the ability to terminate your parental rights so you're no longer responsible for support?
Well, I think that's, I mean, obviously the custodial parent, if they want to do a step-parent adoption and as a process of that, there hasn't been any contact and they want to terminate those rights, they can go and make that finding.
What about the non-custodial parent and says, I've never seen the child, I don't want to pay? Do they have the right to terminate the rights?
No.
even though they've never seen the child, they want to relinquish all the rights. Now, I did a stipulation to that effect on a case, but again, the party stipulated.
Well, I think the problem with stipulations now is I think if you stipulate in the case, I don't think the district attorney later on, if there's any kind of AFDC or welfare benefits, has the obligation to recognize that stipulation. It's really difficult. I think the legislative intent and the understanding that the courts have now is that you can't voluntarily relieve yourself of the obligation or the need to be responsible for a child's economic welfare. You can't do it.
I've got one case where the guy didn't know about the child. The woman goes from state to state. In every state, she's collecting welfare, food stamps, Medi-Cal, the whole bit. And in every state, she says he's the father. In every state, there's an arrearage built up. She's on her third state now, by the way. And all of a sudden, LA is being asked to enforce some of these other court orders he didn't even know existed. And I'm sure with her track record, in the next 15 years, she's probably going to go to 15 more states. Now, how does a guy stop from being hit 18 different states?
Well, what he's got to do is he's got to go in and challenge her for a parenting plan. He's got to go into whatever state she is in to try to develop a relationship with his child and control that situation.
But there we have the problem that the district attorney won't give the information as to where she is. So how do you go to the state and you established a parenting plan and you don't even know where the person is to serve them?
Well, I mean, who knows what all those situations are, but I just still think, I mean, every county, every state in this union is still going to hold the biological parent responsible. They did bring this child into the world. They had opportunities, whether they let them go or whatever, and whether it's fair or unfair, it doesn't matter. This is not. It's not a matter of equity or fairness.
So protecting the child is really the primary importance of the legislature is saying, not necessarily. And that's what you're telling us.
Well, I think the counties want to rebuild their coffers. They basically want the money to come back in that they paid out, and the person that's got the ability to pay, if it's a parent's going to pay.
Sometimes it just doesn't seem terribly fair. We're going to go to break, but again, I'll remind you to give a call at 726-0382, and you'll be able to get some quasi-legal advice from Wild Bill Koch, one of our family law specialists, and myself, Steve Fox. Thanks. Welcome back to the Steve Fox Show, where it's you and the law, where you have an opportunity to call in at 726-0382 and ask two attorneys a legal question and get some free advice. And again, tonight we are privileged indeed to have Bill Koch, who's a family law specialist, who's had over 22 years, and we won't pinpoint his real age, experience in this practice. In fact, you've done other things too, if I remember correctly.
Yeah, I've had other careers within the legal realm, that's for sure.
What have some of those careers been, dare I ask?
Some of them were like in the oil and gas industry, and some of them were in criminal law, and some of them were in real estate. But
and it's interesting how the law crosses in different areas. Like even in family law court, we get a degree of criminal. We call it a contempt, where if someone's been given an order in court, they don't follow it, opposing counsel can file a contempt. Do you want to explain that to our audience exactly what that is?
Well, a contempt is the procedure that you enforce court orders that have been previously issued by a court of law. So in the event if it's like a visitation schedule with minor children or a support order, and that party refuses to comply with it or fails to comply with it, then your remedy is to go into court and file a contempt. Contempt procedures require that you prove that there was a valid order, that they had knowledge of the order, and that they willfully disobeyed the order. And if you can do that for every count of contempt, then the court could potentially incarcerate somebody for 5 days. So it is quasi-criminal. And it's quasi-criminal because there's also a civil side to the contempts in family law, in that if it's a support issue, they do have the right by the family law code to purge it, to basically pay up the money and to make it go away. And so those are important issues.
What kinds of issues are not contemptible if you promise to pay money on a deed or or to give the deed? What is and what is not contemptible?
Well, the 13th Amendment of this country basically provides that you can't be incarcerated for non-payment of a debt. So
no debtor's prison?
No debtor's prison. So, I mean, if somebody has been ordered to pay money and hard times befall them and they don't pay it, it wouldn't be
But if
right
they
to
don't
throw them
pay
in jail.
support, we throw them in jail.
If they don't pay support, we do throw them in jail because it's a commitment to support the minor children, and because it's always modifiable. It's a different concept. I mean, in support, if somebody loses their job, they can come back in and say, you know, I couldn't pay it. Even if they come back into court, they still have the affirmative defense to come back before a judge and say, Your Honor, I know there was a support order, but I didn't have the ability to pay it because I was flat on my back in a hospital.
Well, that would hit them for the contempt issue, but wouldn't they still owe it?
They still owe it, absolutely. They'd still owe that money, and sometime in the future they would have to pay that back plus interest.
I had a guy who came into my office who owed $100,000 in back support to the district attorney. He'll never see the light of day with that type of thing. All I could do is I went in and I used a guilt trip, was basically what I did. So the guy's got 5 kids now. He needs something to support him. And I made a deal with the DA to pay interest only for the next forever. And the debt would always end up being there. But at least now he got out from under massive bills that he'd have to pay the DA. And in the meantime, the reason it went up so high and he hadn't been working is part of the time he was actually in prison. Now, of course, if he knew that, he would have gotten another attorney. He could have gone in court, lower the support, but he didn't. So is he still responsible for paying that $100,000? In other words, can the court still be equitable in the district attorney's office and say we're going to wipe out the debt because you didn't have the capacity?
Well, you know, it's an interesting thing. I was talking to Steve Cooley last night, and I was kind of crediting him with the changes, but I think the Family Support Division of the District Attorney's Office has become really good. I think that the individuals there that man that office are more, I'm not saying lenient, but they're more creative. They're more flexible in supporting the obligations. But I think it's real important. I mean, those people do a really, really good job. I think it's crucial to understand a couple concepts in family support, and that's that there is welfare support, which is reimbursement, which you can't deal with. You're stuck
And you
with
can't
that.
waive that.
You get that. Now and then there's the enforcement issue that's non-welfare, that both parties, if they wanted to walk in and say, you know,
They
King's
could
Heads, we can waive it, we can do whatever.
They could get in other words, the DA goes after more than one type of support.
Right.
One of them is if the other person's been on welfare and built up a debt and penalties and interest, that can't be waived. That's recollection of a debt, and so to speak. But if it's based on an order for support and it's built up 10, 15,000, the two parties have negotiated maybe a flat fee for a certain amount or payments, or they want to get along so they get rid of the debt altogether. I'm not suggesting that. They can do that. They can withdraw it from the DA and they can make an agreement and it goes away. On the other hand, the DA enforcement isn't just give us money. Sometimes they take away driver's license. And it's not just a driver's license. I've had a nursing license taken away. I've had an operator state license taken away. And I've had to renegotiate to get those licenses. The next step is they start putting people in jail. And I've always found that kind of contradictory. If you put somebody in jail, they can't work, then they can't pay off their debt.
Well, you know, I think that was, you know, 270 on the penal code was where they do put people into jail for that offense. They don't want to put them in jail, and they don't put people in jail for a first-time offense. The incarceration for a 270 usually occurs when somebody goes in and they make a deal and they put them on probation, and then they still don't get it. They still don't pay. They still have the ability. They still don't pay. Then they will probably incarcerate them because they don't know what else to do next. And so I think it's just a concept to try to get people to pay. Our jails are full. They don't want to fill them up with 270 offenses. That's not the DA's intent, and it doesn't get money back home to support the children. So I don't think that they do that often, and they recognize the futility of incarcerating somebody so they can't work and further can't pay.
And again, it's like when a kid's bad in school, you suspend them from school, and it seems, I think, defeat the purpose when you put someone in jail for non-payment. And again, people, you can call 726-0382, get some additional legal advice. And Bill, give us your office number again if they want to talk to you later on in the office.
My office number is 949-6727.
And that's Attorney Bill Koch, who's a family law specialist. What are some of the interesting cases you've seen over the years? Can you pick one?
Well, that's kind of hard. I mean, I was talking to you about a couple of them, but I don't know. I think after you've been in this business for as long as I have, I mean, there aren't any. I mean, there aren't the real unusual ones. Don't really stand out so much. I mean, people like to think that a lot of people are absconded or taken out of state, and that just doesn't happen that often.
Bill, we have a call. Attorney Steve Fox, can I help you?
Sure, this is Robin. I was wondering what the advice would be to somebody who's been paying support for 7, 8, 9 years on a marriage that might be 18, 19, 20 years old. What would you recommend about possibly terminating the spousal support?
Well, let's go over that slowly. You're saying it's a long-term marriage, over 10 years, and your question was they've already been paying for a period of years, and your question is you want to know what the possibilities of terminating it is?
Yes.
Bill, I'll let you handle that one.
Well, the issue on that is whether or not the party that's receiving that money has become self-supporting or not, and whether they've diligently attempted to do so. If you've been paying for a period of time and a certain amount of money, the first thing that a lawyer would evaluate is, has there been any change in the economic status of either party? If the person that's receiving the money has been doing fine and has now bettered herself or himself and is making money along with the support, then yeah, I think you could come back and I think you could terminate it. I think there is a desire by the judiciary to want to terminate when there's a cause for it. But if the party has that what we call, like I said earlier, like the pathetic factor, maybe they're terminally ill or unable to ever work again, then it would be a different thing. But you can always come back. You can always go to the court and ask them to modify a spousal support order if there are changed circumstances and if that person has diligently tried to find work, or even if they haven't done that. It might be an opportune time to go into court and get what we call the Gavron warning, to ask them to go to try to seek further employment, so that you could set it up to later on, maybe in a year or two, go back to court and then ask the court to terminate.
Is there a chance that if the person asks to terminate, the other party could actually get more money?
Well, not really, because it's not like child support. Usually spousal support is based on the lifestyles that the parties had when they were married. They don't have the right to or the ability to enjoy the fruits of somebody's success later on after date of separation. That's not the purpose of spousal support. It's to basically lock them in for a standard of living that they had in at the time they're married, but definitely not to punish the payor, because now that he's left this person that was dragging him or her down to be able to come back and ask for more money. That's not the purpose.
Thank you, gentlemen.
Thank you.
Our pleasure. And which again is an interesting question, that there is a difference in the purpose between the child support, which as the income goes up, you end up paying more.
Well, child support, I mean, the legislature believes very strongly that the children ought to participate in whatever the wealth of the two parties are. So if somebody wins the lottery, absolutely, that child is going to get the windfall benefit of that money.
You know what I've seen, and I kind of find it objectionable. I have one client or alleged client who's got all the children, 6 children, and they're also the high wage earner. And the other spouse only sees the kids 20% of the time. But they're receiving child support for that 20% of the time because they don't make any money. What is your feeling on that?
Well, I think, on the one hand, you can look at it and think that it doesn't feel right, but on the other hand, you can look at it, and probably the right understanding is that no matter what, the children, if they're spending time with a non-custodial parent that doesn't have any resources, they should be able to participate in whatever that wealth is in some way or another.
Another phone call. Attorney Bill Koch with Attorney Steve Fox. Can we help you?
Yes. Can a third party hire an investigator on behalf of the person who is being sued or suing to bring evidence in, say a deadbeat father who claims he has no income?
Well, I think the court always wants all facts possible. I don't think it's tainted necessarily because somebody else may hire the investigator. I think it's tantamount that you don't want to violate anybody's right of privacy or rights. But I've gone into cases where we're fighting over spousal support. Spousal support can be terminated if somebody is cohabitating. And the other side brought in an investigator to show that my client allegedly was cohabitating, and that information was admissible. Bill?
Well, I don't think it matters who pays for it. I think it's fine. I think if somebody's gathering evidence on behalf of somebody else, that's fine. I don't think there's nothing wrong as long as it's done legally and for a legal purpose. It's fine.
That's admissible in court?
Well, it is as long as it hasn't been obtained illegally. Sure.
Okay, thank you.
Okay, with that, we have another question. Bill, you're very popular. Attorney Steve Fox with Attorney Bill Koch. Can we help you?
Yeah, I have a question. I have a court order from the district attorney for child support, and my ex-wife went on general relief, and she's playing the system. What can I do to get some money out of her to get something to happen?
So say that again.
Okay, I have a court order from the district attorney for I'm the custodial parent.
Okay.
And she's supposed to be paying me support, but she went and got on general relief, and she's playing the system. And they say that there's nothing they can do to enforce the order.
Well, the key issue is whether or not, as long as the order stands, normally we would advise our clients that as long as that order stands, it's always going to be enforceable. The problem is that your situation right now is you don't have anything to force it against, but
right.
You can only hope that sometime in the future you will.
Now, the other thing is if you have an order, say $300 a month, and she's not paying, that order is going to build up. The second month, another $300. She's going to owe $600, and it keeps going. And I believe you can go back 10 years. It's a moving target if someone hasn't paid, and all of a sudden when they do make it, you can go after all your money with interest.
And I think that's true. I think that's what you need to do is sit back and watch and feel that if you're not getting it now for the support of your children, hopefully you'll get it later on when they need it, maybe for college or to get a car later on in their life. Just keep watching and looking for it. And
it's already been like 2 years.
Well,
nothing's happened.
Right, and 2 years in the life of an order is not very long, but I know it's frustrating. But there's just no way to attach something if there's nothing to be attached. But someday, whether this person gets married or has joint assets or does something like that or owns some property maybe or gets a job, you'll be able to collect and attach it.
And can't the court, pull her into court and tell her, hey, we know that you're, doing everything you can to avoid it? Because she tried to get on Social Security, they wouldn't do it, so she finally got the general relief thing.
Well, you can, that's a really good point. And what's important about your point is that if you were to go in now and do that and ring that bell, the next thing she could do is go in and modify the support and make it zero. Your best shot now is to sit back. You've got a support order, let it toll, let it mount up.
Okay, thanks a lot.
Yeah, it's better for you, yeah.
And again, how much is the interest per year that is gained on that?
Well, the legal rate of interest is 10%. So it's worthwhile.
Well, it does build up, and I've seen, as I told you, I had one case that went up to $100,000. Well, Bill, we've got a couple minutes left. Is there any message you want to give, and your phone number again, to the public and suggestions as they're about to go through a divorce?
Well, my number is 949-6727, and I just want everybody to understand that they should be proactive. They should try to manage their case in a way to feel like they're part of the process instead of just being whipped around by it.
And Bill, forgive me for interrupting, but you're so popular, we've got another call. Attorney Steve Fox with Attorney Bill Koch, can we help you?
Yeah, I got a question. I'm a non-custodial parent, and pretty much for the length of time on my child support, it's been coming out of my check. And the way my wife's attorney had it set up, the check went directly to her and didn't go through the court trustee. And now they're showing that I owe $40,000, and they're saying it's a gift. Is there anything I can do?
Well, on a situation like that, that's what I was talking about. Is I think that my thinking is that the district attorney is a little bit better than they were before. I think if you were to file a motion to ask for them to actually do an accounting of what you owe, and if you could go on with proof of what you've paid, they will give you credit for that. I believe that they would do that now. Now, it's true that there's an obligation for you to pay through the court trustee, but there's a wage assignment, and that's not your fault. It's done by your employer. So I think you'll be okay, but make sure you keep all the evidence available, and when you go and talk to the DA, then I think they will give you credit for that. I don't think that would be a problem.
Okay, what kind of evidence are we
First of all, it's called a motion to do accounting to determine arrearages.
Okay.
And what you do is, unfortunately, the burden is still on you, where you might want to show pay stubs that show the money taken out, a letter from the employer. If the money's taken out of, say, your federal income tax, you show. They'll usually send you a slip saying this is what your return was going to be, and here the money's taken out. You put all that documentation together with your motion to determine arrearages. That motion gets you into court in front of a judge, or at least for the DA to say, yes, you're right, you did pay, therefore we were wrong in charging you. And it's not a gift, by the way, because you did pay. Therefore, it's just a matter of making the left and the right hand know what each other is doing.
Right. We did go to court on it, and the wife was willing to dismiss it, and they said it was no longer her ballpark. It is now owed to my child.
Well, that would only be, it depends. What county is it in?
It's in the Lancaster courts here.
Okay, well, I think if you were to sit down, I mean, if they did an accounting on that, and it depends on if it was welfare or not, but if it was reimbursement, you might be able to revisit that later on. But it depends on what kind of order. If you have an order with prejudice, you're going to be stuck with it. If it's without prejudice, then, and you'll say so on your order, you could go back and make that argument.
Okay. Thank you.
And with that, again, we'd like to thank you for tuning in. We're on every Thursday night from 7 to 8. Welcome again to the Steve Fox Show, and tonight we were lucky to have Wild Bill Koch, and I want to thank you for being on our show.
Well, thank you, Steve.
And we deeply appreciate it. And one more time, give your phone number to the public.
It's 949-6727.
Thank you very much.
Good night.